Hello and welcome to the FLCC 2022 Constitution Day program. My name is Dr. Eric Duchess. I'm an associate professor of history here at the college, and I'm joined today by my colleague, Dr. James Valenti, associate professor of criminal justice. And today, in honor of Constitution Day, we're going to talk a little bit about the workings of the Supreme Court. The Supreme Court is, of course, one of the three branches of the American federal government, and it serves a very unique and important function in it. If we look back at colonial times, one of the potential problems in the British system was a lack of the separation of powers. While it's true that the Parliament limited the power of the king, they almost completely limited the power of the king and accumulated all of the power themselves. There was no independent court system. And when the disputes with the American colonies began to arise in the 1760s and the 1770s, there was no legal mechanism in which the British government could deal with these disputes. There was certainly a deficiency in that system, which helped lead to the American Revolution. Indeed, our own Articles of Confederation, which was our first constitutional arrangement, did not provide for any national courts. There were only courts at the state and local level, which meant that interstate disputes could not be easily resolved in an impartial arena. What happens when a merchant from New York City has a dispute with his counterpart in Philadelphia across state lines? Whose courts would apply? Where would you go to seek a remedy? There was no ability to resolve the disputes between the states. For example, the state of New York was in a very deep and bitter dispute with the state of New Hampshire over Vermont. Which state would be able to claim this territory? And there was no legal arena where these results or these disputes could be resolved. Under the Constitution, with the full-fledged idea of the separation of powers, the federal court system provides that legal arena where those kind of disputes and more can be resolved. The Supreme Court of the United States is the only court that is specifically outlined in the Constitution. And today I'd like to speak with Professor Valenti and interview him, if you will, about the life of a Supreme Court case. Where do they come from? How does a case make its way from a federal or a state court to the Supreme Court? Who decides what cases will be heard and what cases will not be heard? How do the deliberations take place? How do the justices prepare themselves to hear the case? How are the arguments delivered in the court? Is it the same as a regular court of law, or is it different? Or is it a little bit of both? And these are the kind of questions that over the next 25 to 30 minutes, I would like to explore with my colleague, Professor Valenti. Professor Valenti, thank you for agreeing to join us for this conversation
Thank you.
today. So could I start then at the beginning of the life of a Supreme Court case? What are the ways that a particular case might arrive at the Supreme Court?
Okay, now there's actually a couple of different ways. And when the Supreme Court takes a case, whether it's from a state high court or from having the case having gone through the federal judiciary, the district court, the U.S. Court of Appeals, and then the Supreme Court, when they agree to take it, that is called granting a writ of certiorari. Okay, and they usually take cases where, for example, states have disagreed about a particular issue, or where those circuit courts, those lower federal courts, which were created by Congress, okay, actually in the, well, I'll talk about that in a bit, but the lower federal courts, if the circuits disagree about something. Now, let me just say a few words about a lot of different related things. Number one, you're right, the Constitution only created in Article 3 the Supreme Court of the United States. And what they said in there was the Supreme Article 3 of the Constitution said that the federal judiciary shall be the Supreme Court in such a lower courts as the Congress may deem or in effect create, establish, they said. And that's just what Congress did. Congress created the lower federal courts. They first created the circuit court, the district courts. And then what they did was they created the Circuit Court of Appeals, but that wasn't until the formal Circuit Court of Appeals in 1891 when they ended circuit riding. Okay, so cases are either from a state's high court, and if the Supreme Court, SCOTUS as we call them, Supreme Court of the United States, if they accept it from a state's high court, and oftentimes these cases, whether they're from the circuit courts or the Supreme Court of the United States, they're more than one case. They're a few put together, like Brown v. Board was about 4 cases put together, all having the same issue about segregation. Now, if the court, for example, grants certiorari in a case that came from the state's high court, when the court of last resort or high court of a state has made its ruling, the petitioner, the one who wants their case heard, does not have to start at the bottom of the ladder, the district court, and then go to the circuit court. They can go straight over in certiorari if the case is accepted to the Supreme Court. And
Professor, would an example of that be the Bush versus Gore case during the election of 2000, where a case went directly from the Florida Supreme Court to be reviewed by the U.S. Supreme Court?
Excellent. It actually went up there a couple of times, and the court has the rule of 4, which says that 4 justices, if 4 of the 9 agree to hear a case, then certiorari will be granted. And and that's the actual path. Now, there's one other type of case that they take, but they send out, but they take this one in what we call original jurisdiction, where people can come straight to the Supreme Court of the United States. And that is where one state sues another. And that's happened a number of times over the years. One of the more, I guess, one that might have more crowd appeal than others might have been New York and New Jersey having a dispute over Ellis Island. So that can come straight to the Supreme Court, but what they do is they send it out to a special master. And then the master reports back to the court.
Professor, once the Supreme Court does decide to hear a case, how do the justices prepare themselves for the actual meeting in court where arguments will be heard? And who will be arguing the case before the justices? Can any attorney argue a case before the Supreme Court, or do they need a special credential?
Well, Professor Duchess, in terms of a special one, I think you'll find that you either have to argue a case admitted before the Supreme Court bar through the traditional realm, or I know that they used to allow someone who wasn't admitted formally before the court to be sponsored by another attorney for just the purposes of arguing that case. But to be honest with you, I don't know if they called it pro hoc vice, but I don't know that you can still do pro hoc vice, meaning if you're an attorney that's admitted before the court and I'm not, you might in effect vouch for me and make a motion and say, Your Honor, for the purposes of this case, I would like to move that counsel Valenti be allowed to. I don't know if you could still do that route now, to be honest with you. But I think the practical matter is you get admitted before the Supreme Court itself to be able to argue cases, and so
Well,
few go there.
it's
So
taken me
few
8
cases
years,
get there.
Professor. It has taken me 8 years to find a question that you couldn't answer immediately, so I'll take that
Well,
as a personal. But what happens during the actual arguing before the Supreme Court? Is it like a traditional courtroom, or is it like an appeals court? I mean, how does it actually work? Just briefly, if you please.
in effect, it's an appeals court. That means there is no jury there. That means that the facts have been determined. The only issue here will be whether the lower courts, in effect, erred on the law. There's no jury. There's a panel of 9 justices. And they will ask counsel on both sides questions. Each side has, in most cases, about half an hour to present their case. It's usually a hot bench, meaning the justices are firing questions away, although they've moved a little bit away from that since COVID and since some other suggestions about how oral arguments should be conducted and how questions should be conducted. But it is basically a half an hour for each side to try to make their case as to why their side should win. And what they're really doing is they're settling federal law. It's either going to be, like federal statutory law or federal, sometimes even administrative type law or whatever. But usually it's constitutional law, parts of the Constitution that they're looking at. And they're the final arbiter of federal law. And they're interpreting federal law. And if you ever want to trump or override a Supreme Court decision, there's a couple of ways. Either they reverse themselves later. We saw that in Dobbs recently with regard to Roe. Or a way to do it would be, for example, you would need to amend the Constitution, okay, as provided in Article 5, and that would require 3/4 of the states to agree to that amendment. There's a couple of ways they can start the process.
It's interesting that you mentioned the court overriding its own previous decision. Just before we went on today, I did a little research, and since the year 2000, and that includes 2000 up until today, the court has overruled previous decisions on 28 occasions. That's a little bit more than one per year or one per session. Usually it seems, as I was reviewing the cases, that the cases that are being overruled from the past do not tend to be landmark cases, which, again, the Dobbs case, which overruled Roe v. Wade, that is one of those occasions where a so-called landmark decision has been overruled. But you actually anticipated one of my questions there for you. And I did have another question for you. What happens if one of the justices perceives that they have a conflict of interest in a particular case that is being brought before the court?
Well, by the way, I always, learn something when I'm around Professor Duchess, and whether it's I ask him something or he offers it. And I didn't know that stat on the 28 uh, within the last, what was it, 20 years or
Since
whatever.
2000, yes.
Now, if a justice believes that they shouldn't sit on the case because maybe they sat on it when it was in the lower courts. Sometimes they will do what we call recuse themselves. And what that means is they will say, on this particular case, I will not sit. So sometimes, for example, you'll have 8 rather than 9, which really doesn't pose a problem unless it's 4-4.
Right.
You
Well,
know,
I was going to ask you, Professor, what happens when a case has a 4-4 tie or a
the
3-3 tie for that matter?
the 4-4 just means that the last go around then, in effect, I think we'll find would win, meaning whatever it was in the lower court that would stand. And and it is possible that they could have a 4-4 and the lower one stands, but what happens if the justice is added? I think there are ways too, whether there's a justice added or not, that you can ask for a rehearing, but most of those are denied for obvious reasons. So,
Well, I had one final question for you, and I
mhm.
suppose it's appropriate to ask this question at this point. After the arguments are made, the justices retire to their chambers and they can deliberate with one another. Um, is there a specific timetable on how long the justices can deliberate before rendering a decision, or is that left up to the justices themselves?
Well, ultimately it's their call, but what they do is the justices meet together in conference and no one else can go in that room. When they meet together, they meet to do one of two things, and they usually meet a couple of times a week. I'm saying separate from the time they're sitting on the bench, hearing cases or rendering summaries of opinions. When they're together in conference, they are deciding which cases to grant certiorari in. That means which cases to hear. But then they're also discussing how they're going to vote on a particular opinion. And then the opinions will be assigned. And sometimes there's a unanimous opinion, about 40% of the time. There's usually a majority in dissenting. Sometimes there's a concurring. Opinions are circulated within within the
Professor, just for
justices.
a point of clarification,
And
when you have a majority opinion, they are obviously speaking for the majority of the court, but then you mentioned the thing, the concurring opinion. Isn't that when a justice votes with the majority, but for different reasons? For
exactly.
example, they, 2 + 2 = 4, but they arrived at the end result by saying 3 + 1.
Yeah, like for example, the example I give might be just, you might write the majority opinion. Uh, you might end up, but I might end up agreeing with you with regard to the result, but I write a concurring opinion because I think rather than it being the petitioner wins on the Fourth Amendment grounds, it's a different amendment, or it's something else. It's for a different reason.
Same
I come
result,
to
different
that
means.
conclusion, and so that's why lots of times too, somebody's opinions. I mean, I make it a point to read, the big ones, and some of the ones that aren't quite as big. Most of the opinions, they can come out anytime, come out at the end of the term, which is usually the end of June, the first part of July. In a couple of weeks, they'll start up again by statute. First Monday, In October is when they start hearing cases. So the term is from first Monday in October until the end of June, early July. There might be one that trickles after the 4th, but usually not. So the answer to that is that's a common time when they come out. And I might agree with you with regard to result, but for a different opinion, a different reason for that. And that could be important for the future.
Professor Valenti, thank you for taking time out of your day to discuss the ins and outs of the life of a Supreme Court case with our viewers. As always, it's been a pleasure. And I thank our viewers for spending a little bit of time with us celebrating Constitution Day 2022.
Well, I
And
just
who
wanted,
knows, next year we could have, who knows what surprise we could have in line for our viewers next year. So stay tuned.
well, Professor Duchess, it's always a pleasure to do these, and I'm always happy, quite frankly, to have you do the introduction and to walk us through that and to sort of set the stage or set the table and give us that background because quite honestly, not only is it something that you know more of, but I actually think that's the harder part. And I haven't told you this privately, but you always do that part. And I always I think I'm honored and blessed that I have the other part to do. So I don't have to do that intro and set that stage. So thank you.
Well, we've got all the bases covered. And with that, we will thank our audience for spending a
Thank
little
you.
bit of time with us. And we look forward to seeing you all again next year.
Thank you. Take care.
Goodbye.
And we'll be seeing you. Bye.